Your solar panels are a blight on this entire street, and we are taking you to court to have them removed. I was standing on my own front porch, a wrench still in my hand from tightening the last mounting bolt, staring at the HOA board president, a woman named Patricia Wynn who ran a boutique real estate office. She had a clipboard pressed against her chest like a shield, and 2 board members flanking her, both wearing the same tight-lipped disapproval. "I just finished the install," I said. "They're not even hooked up yet." "Doesn't matter. The covenants require board approval for any exterior modification. You didn't submit a single form." "I did, 3 months ago. You never responded." She flipped a page on her clipboard. "We have no record of that submission, and even if we did, the aesthetic guidelines are clear. Panels visible from the street are a violation." I didn't argue. I just closed the door and pulled out my phone. I had a folder in my filing cabinet with the certified mail receipt, the submission form, and the time-stamped photos of the panels going up. But that wasn't what I needed. I needed the state statute. Over the next 2 weeks, I made 3 trips to the county law library and 1 phone call to a solar rights attorney named Margaret Chen, who took my case on a flat fee. She pulled the exact language from the state's Solar Rights Act, the one that preempts any HOA covenant that unreasonably restricts solar installation. The key word was unreasonably, and the statute had a presumption. Any restriction that increases the cost of the system by more than 10%, or reduces its efficiency by more than 10%, is automatically unreasonable. My panels were ground-mounted. I could have roof-mounted them, but the orientation would have cut efficiency by nearly 20%. I had the engineering report to prove it. The HOA filed their lawsuit anyway. Patricia sent me a letter offering to settle if I removed the panels and paid a $1,500 fine. I didn't respond. The hearing took 40 minutes. Patricia argued that the panels ruined the neighborhood aesthetic and presented a petition with 37 signatures from neighbors who agreed. Margaret presented the statute, the engineering report, and the certified mail receipt showing I had submitted my application on the correct date, with the correct forms, to the correct address. The judge, a woman named Ellen Ruiz who had heard 100 HOA cases, asked Patricia one question. "Did the board ever formally respond to the application within the 30-day window required by your own covenants?" Patricia said no. Judge Ruiz dismissed the case with prejudice and awarded me attorney's fees. The total came to $6,400. Patricia wrote me a personal check from the HOA Reserve Fund, and I deposited it the same day. The panels have been running for 8 months now. My electric bill is down to almost nothing, and the neighbors who signed that petition still wave at me when I walk my dog. The thing is, the law was on my side the whole time. They just assumed I wouldn't read it. Do you know what your state's Solar Rights Act actually covers? Or are you trusting the HOA to tell you the truth?